I'm the executive director here, and I am absolutely delighted to welcome you and to introduce tonight's guest presenter. This is offered through the Mass Bar Association Elder Education Law Project, or Elder Law Education Project, that's right. And so each year what they do is they send, the Mass Bar Association sends out an email to all the senior centers across the state, and they ask us if we would like to host some type of a legal presentation. Of course, I always say yes. And then they must send an email out to all the attorneys and say, would you be willing to do this at no charge? And some of them say yes, and then they match us up. So we never know who we're going to get. But I am really happy that tonight we have attorney Hyman Darling. So this is what I know about Hyman Darling. When I first started in the field, which was a long, long time ago, I've been on this job for 18 years. And prior to this, I was teaching at Springfield College, and I wanted to do a piece on elder law, just a lecture, because I didn't learn anything about that in my program. And so I went to a local attorney who I knew, a younger attorney. She had just gone to one of your trainings, and she showed me the training manual. So I refer to Hyman Darling as the guru of elder law in the greater Springfield area, because he really did train, I think, a lot of the young bucks long before elder law was probably even thought of as, kind of a specialty. But I think you must have had a vision that at some point all of us baby boomers were, going to age and really need to get our affairs in order. So that's what attorney Hyman Darling is going to talk about tonight. I'm going to turn it over right to you.
Thank you very much. Are you sure I'm not getting paid for this? So, yes, I was practicing elder law before it was called elder law. We did estate planning for older people. And then somebody came up with the idea that we should have something called elder law. Can you all hear me okay, by the way? Okay, good. So that we have a new title now. It's called elder law. This is going way back. But before that, I must tell you that I worked in a bank when I went to law school at night. And that was a long time ago that I knew Peter Weston, who's now retired, and I'm still working. What's that about? But we go way back, and I won't say how far back, but I had hair. Okay, so we have a lot of material to get through. I have enough material here for a whole semester, because I teach elder law to other lawyers in the LLM program at Western New England Law School. So that's a whole semester, so you're going to get it all in an hour or so. I'm happy to answer questions for you, but I'm not going to take questions from the floor while I'm speaking, because I'll never get through my material. So write them down, put a check mark by something you don't understand, and I will stay and answer your questions. You really want to ask me questions tonight, and pay attention, because if you call me and meet in my office with me, you will pay for it. It is free tonight. So you definitely want to ask your questions tonight. If I don't get through them all, send me an email. My email's right on the agenda. And say you went to the Westfield program, and just ask your question, and I'll get back to you with the answer, okay? If I can't get them all tonight. So, why am I here? Well, because I wanted to talk to you, because you're here to learn. And I want to tell you about estate planning. And I'm going to get through from A to Z all the issues about estate planning. Everybody here has an estate plan, right? Of course you do. When's the last time you had it updated? If it's more than 7 to 10 years old, it's time to review it and update it. Maybe some of your kids moved, maybe some got married, maybe some got divorced, maybe some, unfortunately, have disabilities or passed away, maybe somebody married someone you really don't like. It might be time for you to update your plan. So it doesn't cost you anything to look at it. Pull it out of that suitcase under the bed or wherever you keep it, and read the documents and see who you named, read the wills, the trust, see what you've done. If you're not happy with it, if you need to make changes, if you don't understand it, there's no shortage of lawyers in Western Massachusetts to call to get this done. Okay, I'm just here to educate you, not to solicit business. So don't hesitate to call your lawyer and say, I have an old will, I think it needs to be updated, You already have it started. All you have to do is finish updating it. You're halfway there. So it's not a big deal. So we're going to talk about what I think are the two most important documents you can have. And that's the health proxy and the power of attorney. You all have a health proxy probably because either you got one at the doctor's office, at the senior center, or at the hospital, because they want to know who's going to make your decisions for you if you can't make them for yourself. Right? If you don't have that document, then you're going to have to get in line and go to the probate court and have a guardian or conservator appointed to be in charge of your affairs to make that decision. That takes time, it's public, and it's expensive. You want to avoid that. But most importantly, you want to pick who you want to be in charge. Most people will name your spouse. If not your spouse, you'll name someone as a backup. You should always have a backup. So if you're naming a brother, a sister, a cousin, whoever, always name someone as a backup, just in case the first person you name can't serve. By the time they're ready to serve, if you haven't changed your document and you become incapacitated, you can't make a change to your documents. You can only sign documents while you're competent. By the way, is everybody here competent tonight? Well, you all got here at the right day and the right time, so that's good. Okay? If you come tomorrow night, then we have to question your capacity. So that's on your health decisions. The documents you get are standard documents. They're okay. It's better than having nothing. I like my document better. It's more complete. It talks about whether you want to be an organ donor. It talks about whether you want to be cremated or buried. It talks about whether you want life support or you don't want life support, and to what extent you want medication to keep you comfortable if you're not going to get better with quality of life. The documents you'll be signing that are just a standard one page don't go into that, and sometimes they don't have a space for a backup. So it's important that you have this document. The next important document is the power of attorney. The power of attorney attends to who's going to make your financial decisions for you if you can't make them for yourself. It doesn't have to be the same person as making your medical decisions. You can have two different people. So you might have one child who's a doctor and one child who's an accountant. So maybe you put the accountant to be in charge of your medical decisions. And you put your other child, the doctor, in charge of your financial, because they're going to work together anyway. But it's important that you consider who you're going to name. Think about who is the best person. If the best person you want to name happens to live in Chicago, not your child who lives down the street and around the corner, then you name the person who's in Chicago. It's not a big deal. Everything is online. Everything can be faxed or scanned or emailed. It's so easy to make decisions and get things done now. It's really not a big deal. So I was told I can't wander around. I have to be right in this area where the camera won't pick me up. So otherwise I'd be walking around here. I don't like to stand still, but anyway. So you all have a health proxy and a power of attorney. If you don't get one, it's not a big deal. You probably know who you want to be in charge and who the backup would be. If you have them, that's great. Take it out, review it, look at it. If it's okay, fine. If it isn't okay, call your lawyer, have it updated. Not a big deal. Okay, you can probably get it, most of it taken care of on the phone. Then you just have to go to the lawyer's office, sign the documents, rip up the old document, put the new one in its place, and you're good for another 10 years. Okay, it's that easy. So does everybody in here have a will? You all do. Is anybody who doesn't have a will? Okay, well, can I ask you, Tina, to help me here? So this young man over here said he doesn't have a will. So he gets a prize for answering the question, although he's wrong. Okay? Everybody has a will. If you don't have a written will, then the Massachusetts law says who gets your assets if you die without a will. Okay, so you have one. If you're married, and it's your first marriage, and your only marriage, and you have no children by anybody else, everything goes to your spouse under the new laws. If you don't have a spouse, everything goes to your kids. If a child isn't living, his or her share will go to his or her children, not to their spouse, but to your grandchildren. But if you're married, and you were married before and you have children by your first marriage, your spouse doesn't get it all. Your kids get a portion, your spouse gets a portion. It's a mess. It's not that hard. You all know who you want to leave your assets to, right? You all want to leave about 90% to your family and 10% to some charity, right? let's think of a good charity. Westfield Council on Aging. Okay, they could use the money, but it's easy for you to get a will done. It's not a big deal. If you have one, take a look at it. You've named someone in that old will to be what's called an executor, right? Well, guess what? Massachusetts doesn't use executor as a word anymore. It's now called a personal representative. So if you die without a will, or you die with a will, the same person is going to be called a personal representative. You wouldn't know if there's a will unless you go to the court and look at the documents. But it's just a name. It doesn't matter. We still call people executors, because if you're executor, we know there's a will. If you're the administrator, we know there wasn't a will. So they changed this to make it easy by calling everybody a personal representative, and then you don't know what they are. I didn't have a say in that either. But you should have a will so that you know who's getting what and who's going to be in charge. Don't be bullied by one of your children who says they want to be in charge. If they want to be in charge, then probably they shouldn't be. Okay? There's no benefit to being in charge, as you know. Some of you have probably served as executors or personal representatives for somebody else in the past, right? It's no bargain. Okay, if someone asked you to do it now, would you say yes? No. Unless you're going to get paid, you don't want to do it. It's just aggravation, and everybody questions you after you've done it and calls you out on it. So when my dad got sick, and he was in Pennsylvania, and I hired a lawyer down there to do his will, his health proxy and power of attorney, my sister said, "What do you think?" I said, "I think you should be in charge of everything." And she said, "I think I should be too." She was in charge for 6 months, and she called me and said, "I'm done." She said, "You got to take it over." She said, "This is too much for me." I said, "Well, you wanted to do it, that's fine, but there's no benefit. It's just aggravation and stress and work that's going to take you out of whatever you want to do during the day, that you're going to be running around doing stuff. I mean, the worst thing you have to do is clean out somebody else's house. Oh, what a chore that is. And God forbid your executor me, okay, because I don't throw anything away. So that's why my wife says we can't move, because I have so much stuff in my basement. I call it the lower level. That's true too. Okay, so you want to pick someone to be in charge of your estate. Now let's talk about what has to go through probate. The only assets that go through probate are those assets in your name alone. Okay, so let me pick on somebody who's married. So we'll penalize someone who sits in the front row here. Sir, are you married?
Yes.
Is that your wife? That's your wife. Why aren't you sitting next to her? Oh. Okay, so you're married, happily married, right?
Yes.
Yes. Okay, so let's say that this couple is married. Let's talk about their assets. They have a house, jointly held. So if one of them passes away, the surviving spouse will inherit the property. That's a non-probate asset. Is it okay if we pretend that you pass away first? You know why? He wants to. Just kidding, just kidding. Okay, so he passes away, you get the house, no probate. That's easy. You have life insurance? She's the beneficiary. She gets that without probate. IRA, 401k plan? She's the beneficiary, right? She gets that without probate. How about bank accounts or stocks? Do you have those? Are they held in your name alone or joint? Joint. She gets those. Is there anything at all in your name that would have to be probated if you passed away?
Maybe something in another, we have property in another state.
Probably in another state, you probably hold that jointly too. So she gets that without probate. So there's no probate. How about a car? You got a car? Whose name is that in? Both names. Wrong answer. Okay. What if the car was in your name alone? Probate or non-probate? You think it's probate? That's a trick question. In Massachusetts, there's a law that says if you die and you don't leave your car to anybody else in the will and you're married, your spouse automatically gets the car. He or she can go to the Registry of Motor Vehicles after they stop by the insurance company, they stamp your paperwork, give you an affidavit, you go to the registry, out you walk with a new title in just the surviving spouse's name. That's a non-probate asset. That's one. If you have two vehicles in your name alone, the trick is just go to the registry 2 different days. Don't do them at the same time. Okay? But then, because no one's going to know. They don't care. But that's how you get around that, as opposed to probating it. We don't want to probate something if we don't have to. So this young man has passed away, and now 20 years later, his wife passes away, and she didn't do anything. Now guess what? The house is probate, the bank accounts, the stocks are probate, but the IRA, you probably changed the beneficiary of that to name your kids, so they get that, but everything else is still in your name. If you don't add someone else's name, you have a probate situation. And the fact that you have property in 2 states means we have to probate your property in 2 different states. You are what we call the Attorney's Full Employment Act. Okay, we like you. Okay, that's a lot more work. But it's easy. All you have to do is add someone else's name to the deed or put it in a trust, and that makes it non-probate. Only assets in your name get probated. I can't tell you how many lawyers I've seen who probate assets in an estate when there's no probate, and then they take a fee on it. Okay? There is no probate unless there's assets in your name alone. Okay? All right, so we're going to move on a little bit here. Sometimes we ask you to also include in your will the same language that's in your health proxy about end-of-life decisions. Do you want to be buried, cremated? Are you an organ donor? Do you want to donate your body? Have you had pre-arrangements? We ask you all those things because it's not fair to your kids if you haven't told them what you want. They're going to make those decisions. And you want to have your remains taken care of the way you want. If you don't tell somebody or prearrange it, it's going to be someone else's decision. And if they're going to cremate you and you don't want to be cremated and dumped in the river, then you need to tell somebody what you want or what you don't want. It's not hard. Okay? If you have burial plots, that's fine. You can be cremated and have your remains put in your plot, if that's what you want. If not, that's okay. Okay, so we've talked about health proxies, powers of attorney, and wills. Okay. I only have another 2 hours. There's something called POD, payable on death. So if you go to the bank, they say, okay, this account's in your own name. You should make that POD, which is payable on death. So when you pass away and you name your kids walk in the bank with a death certificate and they walk out with the money. It's a non-probate termination of that account. The same thing is true of a stock account. That can be TOD, transfer on death. Okay, one's payable on death, one's transfer on death. I don't know why there's a difference, but one's a security and one's a bank account, so that's how it is. So if that's what you want, we can do that. So if you want to avoid probate is not difficult. In 2012, a new law was passed called the Uniform Probate Code in Massachusetts. It made it really easy to probate estates. If nobody objects, we can get you in and out in no time. Okay, it's not a big deal. And there's 3 different types of probate. There's a small form probate if you have $25,000 or less in your name alone, not counting a car. That's real easy. That will be done within 30 days and you'll be done. Then there's informal probate, and I usually use informal no matter what you have for assets, unless you have real estate in your name alone. If there's real estate in your name alone, that's a formal probate, and that takes a little bit longer to get appointed. But no probate in Massachusetts, except for the voluntary, the real short one, can be closed within 1 year because creditors have 1 year to file claims against your estate. So you can't formally close it for 1 year. But if we know there's no claims, we can get you in and out of probate within 3 to 5 months. It's really not a big deal. Then we just wait 1 year to close it in the court. It's not difficult, okay? And if nobody objects, you never have to go to court. Let's talk about trust for a minute. Do you ever watch TV and you see either Susie Orman talking about why everybody should have a trust? You ever see her on public TV? There's another guy, Rajiv Nashak. He's from the state of Washington. He's doing it now. Have you seen any of their TV programs? I know Rajiv personally. Susie Orman, I don't know. I don't think I want to know her. We don't always agree. Anyway, some people say that everybody should have a trust to avoid probate. Well, in your case, by making everybody joint or as a beneficiary, I've avoided the need for probate. The other thing that you can do to avoid probate is to add your children to the deed. Now, you might not want to do that, but I've given you an article I've written called Life Estates. And some of you have a life estate. I know you do. And you deeded the property to your children, and you reserve to live and use that property during your lifetime. But when you pass away, that property automatically passes to your children, and it doesn't go through probate. It's that easy. Okay? But you have to add their name to the deed now. If you don't want to do that, you don't have to. But then maybe you want to set up a trust to avoid probate for that property. And if you've got property in more than one state, you definitely want to do something to avoid probate in 2 states. There's just no question you should do something. But you can either add the kids' names to both deeds. If you don't want to do that, you set up a trust and you say, okay, I'm setting up the John Doe Trust. And I'm the trustee of that trust while you're alive. John Doe's the trustee. Total control of the assets. John Doe dies or becomes incapacitated, you name John Doe Jr. to be your backup trustee, and he administers that property, and if you pass away, he sells it, divides the money, distributes it the way you want to under the trust, and it's done. All outside of using the probate court for the way to transfer that property. Now, the trust is going to cost you more money. So it's like the old Midas Muffler ad, pay me now or pay me later. So either you pay for it now, and then you avoid probate fees later, or if you don't avoid probate now, it could happen, and you could be then sitting with a probate estate after you're gone. You probably won't know it. You're not going to come back and tell me, right? If you do, tell me so I can write a book and make a few more dollars doing that. Okay, so not everybody needs a trust. Some people need a trust because they've got children that aren't responsible. They don't want them to get the money in a lump sum, so you distribute it, a third at 30, a third at 40, a third at 50, and you dole it out to them over a period of time in case they dissipate it, or because you don't really like their spouse, and you, in case they get divorced, you don't want all that money to be available, which it would be as marital property, so you dole it out to them, and you name a trustee to handle that money. That's not a big deal, okay? That's easy. I've got lots of clients who have kids that have disabilities, and they're on governmental benefits. And if the kids receive that money, they would lose their benefits. So we have to keep that money in something called a supplemental needs trust. I've got clients who have kids who have alcohol problems, drinking problems, drugs, gambling. If you leave them that money, you're not doing that child a service because they're just going to blow through that money and cause harm to themselves. So we set that money up in a trust where we dole the money out to them also at the discretion of a trustee. So there's lots of reasons why you should have a trust. Some people don't like their children, and they want to skip their children and leave it to their grandchildren. That's okay. There's only one person you cannot omit in your will. Your spouse. You cannot omit your spouse. You can omit them, but they can challenge the will and get a share of the estate no matter what afterwards. So you can't leave him out. You got to leave him something. If you don't, it's okay, but he could challenge it. He won't. But there's no law that says you have to leave your children anything. Okay? You don't have to leave them anything more than you have to leave your nephew, your cousin, or anybody else. There's no obligation to support a child in your will. You might have an obligation to support them while you're alive, but after you're gone, there is no obligation. So, you got to think about it. If you have a son who's married to somebody that you really don't like, and you leave him his $200,000 bequest, and then he gets divorced because his wife is waiting for you to die for him to get his distribution, then what will happen is she'll then file for divorce and get some of that money you've left him. Well, if you leave him half of that money and leave his kids the other half, the most he's going to have to pay his soon-to-be ex-wife is 50% of what he got, which is only a fourth of what you've left to that family. So there's ways you can structure this easily to cut that person out if you want to. All right. Who wants me to talk about taxes? I love talking about taxes because there's so much you can do to avoid paying taxes. It's so easy. So, I don't want anybody to look at the agenda right now. I want you to all look at me. All right? So let's decide who the richest person in this room is. I think it's this guy right here. Okay? So he's the richest guy in the room. So how much money can he give each of us right now without having to file a gift tax return? How much? 10,000. It's gone up. What is it now? 17,000. So he can give each of us $17,000 every year. He doesn't report it. We don't report it. And what we say to you is, I'll see you in January. Okay, you'll do it again. So he can give 17,000. So if there's 50 people in this room, he can give $850,000. Right? Got $850,000 to all of us, and all we do is say, thank you so much. We don't have to report it. He doesn't report it. That's just the level of money he's allowed to give. It used to be 3,000, then it went to 10. Now it's indexed for inflation. It goes up every year if inflation goes up. If inflation doesn't go up, it'll stay at 17,000. That doesn't count how much money he can give charities. It doesn't count against how much money he can pay for a grandchild's education, or a grandchild or a child's medical expenses. That's all in addition to the 17,000. If he's married, he can give, with his spouse, he can give 34,000. So that 850,000 just went to 1.7 million. He and his spouse can give $1,700,000 away, and now it's not in his estate. Boy, was that easy, huh? So, anybody here with their parent? You're here. Your parent is here? So, do you know what your daughter's thinking right now? I'll show you. This is what your daughter sees right now, okay? She is happy. I am now her best friend, okay? She was so excited I was here tonight. It's so easy. This is what you can give away. This is the federal limit of what you can give away every year without causing any tax. So if God forbid you're not well, don't wait to give money in Christmas time. Give it away now. Get rid of it. If you have enough money that you can afford to give it away, be generous. So, how much money can he give away without having to pay any federal gift tax? $12,920,000. He can give that much money away without having to pay any gift tax. It used to be $10,000, and if you gave away money, you were paying 40 or 50% in gift tax. The gift tax and the estate tax are the same number, $12,920,000. He can give away in addition to $17,000 per person per year. If any of you have $12 million, I definitely want to talk to you. Okay? That's a lot of money to give away. That's the federal limit. So you can give that much money away and get rid of it, and it's out of your estate, and when you die, you have the balance of whatever you haven't given away up to $12.92 million. That number changes every year for inflation. If the law does not change, and it's not extended, in 2026, that number is going to be reduced to $5 million indexed for inflation as of 2010, which I'm going to estimate is between $6 and $7 million. So if you don't have $6 million, don't worry about it. But if you have more than $6 million, you should be giving away money before 2026, before the exemption goes down, because you'll be grandfathered or grandmothered in if you make that gift before the law changes. So if you have that kind of money, you should be giving it away. Okay? So let's say he wants to give me $117,000. So he gave me $117,000. The first $17,000 is free, right? We all agree with that. We know that. The next $100,000, does he pay tax on it? No. He reports it so that when he dies, his exemption of 12.92 million is now only 12.82 million. Do we care? No, he's not gonna have a tax to pay. I mean, if you have that kind of money, you should be doing something very aggressive right now. But in most cases, you don't have that kind of money, you're not going to pay a tax. But it's good to file the tax return just to establish that you made a gift. Okay? Now, I told you, I love taxes. Let's talk about the mass estate tax and the mass gift tax. What's the mass gift tax? Mass gift tax. I heard 17,000.
Zero.
Who said zero? All right, I can't walk back there, but you get a chip clip, sir. Massachusetts does not have a gift tax. Okay? Thank you. We don't have a gift tax. I shouldn't say that too loud. Somebody in Boston might hear us. Okay? No gift tax in Massachusetts. There's no forms to file. There's nothing to do. You just give it away. So if he gave me $1 million, for federal purposes he reports it, but for mass purposes, he doesn't do anything. It's that easy. So why don't people give more money away? Because you might need it, right? You just might need it. How many of you have life insurance policies that have cash value? Okay? Have you ever borrowed against that cash value? Do you need that life insurance? Is there a pocket in the coffin that says reserved for life insurance when I die? You're not taking it with you. When you pass away, it's going to be paid to somebody else. Do you really need to own that policy? Because when you die, the death benefit of that policy is added into your estate for mass estate tax purposes. If you give that policy away and you live for 3 years, that policy will not be taxable as part of your estate. So now let's talk about the mass estate tax. If you have a spouse and you leave any money to your spouse, there is no tax between spouses. It's a federal rule and the state rule. No tax between spouses. So if you were married to Bill Gates and he died and you got his zillions of dollars, you get all that money without any estate tax. It's that easy. There is something called the unlimited marital deduction. No tax between spouses. So those of you who are single, you want to run out and get married? I don't know about that. If you're going to get married, make sure you marry somebody wealthier than you. So when they die and leave you the money, you don't pay a tax. Massachusetts has this tax. It's called an estate tax. It used to be an inheritance tax. It's now an estate tax. If you die and you have $1 million or less, there is no tax. But that includes everything. Your stocks, your bonds, your life insurance, your bank accounts, your retirement plan, your cars, your jewelry, your collectibles, the stuff in your house. Everything you own is taxable when you die. If that number is greater than $1 million, there's a tax to pay. The tax rate starts at 3% and it goes up to 16%. So the tax on $1 million is zero. Once you get above $1 million, 3%, $30,000. The tax on $2 million, 5%, $100,000, give or take. And it goes up from there to 6%, to 7, to 8. It gets high. So 30,000 is not too bad at 3%. But when you get to higher numbers and you're paying 10%, on a $5 million estate, you're paying $500,000 in tax, which could have been avoided by giving money away because Massachusetts has no gift tax. So now you're saying to yourself, well, this is pretty simple. If I have $2.5 million and I give away, gotta do the math in my head, you have $1.5 million and you give away $900,000. How much is left? Less than $1 million, right? You give away $900,000 and you had $1.5 million, you only have $600,000 left, right? So you say, oh, I'm below $1 million, I got no tax. Not so. Massachusetts has a different rule. And the rule is that when you die and you made a gift, they add back to your estate the amount that you gave away during a lifetime. So if that amount added to what you have when you die is greater than $1 million, you'll pay a tax. But the tax will only be on what you have left. So the money you give away still escapes taxation. So now you're paying less tax on less money at a lower rate. So the more you give away, the less tax your children will have to pay. Now, you worked hard to make some money. When you were starting to work, my guess is your first job didn't produce $30,000 a year. I know when I started my first real job, working for the bank, 72, okay? 1772, I was getting $2 an hour. Okay, I remember it because I was taking home $68 a week and I had to pay for my rent, my food, and I was going to law school. And I needed a car because I was traveling around all the different branches of the bank. And I said to somebody at the bank, listen, my car died, I need a car loan so I can get to work. He said, you don't make enough money. I said, did you hear what you just said? You're my employer, you're telling me you're not making enough money. I did my father, who was only getting Social Security, co-sign my loan so I could get a car, a used car. But that's how it was. And then, 3 months into the job, I got a 25-cent an hour raise. That was 10%. I thought I was rich, okay? I mean, that's how it was back then. Okay, so it's easy to reduce your estate tax. Now, there's a bill pending in Boston, and there's been one pending every year for the past 7 years to increase the exemption. Maura Healey said she was going to make it $3 million, but it came out of committee, it's only $2 million. So that $1 million will go to $2 million, but you're only going to pay a tax on everything above $2 million, not back to the first dollar. That's a big deal, because if you were married, you each had a $1 million exemption. But if you went over the million, only the first person who died got a $1 million exemption. Now if you have $4 million, you'll each get a $2 million exemption, and you'll only pay taxes above $4 million. That's pretty good, isn't it? Okay, that's a good deal. If it ever passes, you know what that is? If it passes, it's magic. Okay? A magic wand will make that $1 million into $4 million. What a great deal. You know what you have to do? You have to write to your state rep and your state senator and say, pass this law. This is the same law we've had for 20 years on the books. No indexing for inflation for 20 years on this. It's time to increase it. Everybody who lives east of 495, who has a house and a retirement plan, has $1 million. Everybody who has a house on Cape Cod or Martha's Vineyard or Beacon Hill, they all have $1 million. It's time to change it. A lot of you are millionaires. You don't think you are, but you add your assets together, you've got $1 million. And if you do have more than $1 million, there's going to be an estate tax. It should be at least $2 million, if not more. There's only 8 states that have an estate tax. We're the second worst. The worst is the state of Washington. Do not move to the state of Washington. But you move over the border to Connecticut, you got an $11 million exemption. Move to New York, it's I think 5.7 million. Florida and New Hampshire, no estate tax, no income tax. Okay? You want to be in New Hampshire all winter? I don't know. If not, go to Florida. All right. So now you know about the estate taxes. It's easy to get rid of your money. I know it's a little bit complicated, but it really isn't when you think about it. It's easy to give your money away, reduce your estate to a lower level so there wouldn't be an estate tax. Now, maybe you want, if you're in good health, maybe you want to sit tight for another month or two and hope that this law passes. If it doesn't pass, then you got to get into high gear and start making some gifts. Okay. A lot of you own a house, right? And you probably all have homestead declarations if you own a house, which protects you in case somebody sues you or if you file bankruptcy. It doesn't protect you against long-term care expenses. And you know the $17,000 that you can give away for tax purposes? That's not for Medicaid purposes either. That's only for tax purposes. We're going to get to that. But the homestead declaration is something you have. Those of you who don't have one should have one, and I'll probably regret this, but this is something you can probably do without a lawyer. You can go to the Registry of Deeds website or go to the Registry of Deeds in Westfield, get the form, they'll help you fill it out, you pay the filing fee, and you're done. It's a one and done thing. It's that easy. If you get stuck, I'm sure they'll help you, but they're very cooperative about assisting you with this kind of a thing. This is something you really don't have to pay the lawyer to do. If you sell your house and move to another house, you got to file a new homestead on the new house. It doesn't get transferred. Okay? If you add your kids to your deed under that life estate deed I talked about, your kids cannot file a homestead on your house unless they live in that house. They're living somewhere else and they're filing a homestead in their own house. You only get one. So if you have a house here and a house at the Cape, you only get one homestead. You don't get it on both houses. But if you're married and your spouse lives at the Cape more than here, which might be a good thing, they can file a homestead down there and you can file one here. But you can each then get one, but you can only get one homestead per person. I'm going to just skip ahead for a second. Real estate tax exemptions. If you're disabled or elderly or you have low income, you might qualify for an exemption on your real estate taxes. All you have to do is go to town hall and get the form and see if you can qualify for the abatement. I don't know if Westfield has the deal that some towns have, that if you work at the polls during election, they'll take some money off your real estate taxes, but they won't give you any money. Do they do that here?
Yeah, the
Okay.
property tax, not working the polls, but yeah, that's property tax.
Okay, but there's an exemption, and it's real easy. If you qualify, you get it. You can take $500 a year off. If you're 100% service-connected disabled veteran, you don't pay any real estate taxes at all. You just have to file for the abatement, and you'll get it. It's that easy. But you can go to town hall, and they'll help you with that too. An umbrella policy, if you have assets, you should have an umbrella policy to protect you if you get sued for any reason. I got my first umbrella policy when my kids started to drive, okay? So I had to increase my exemption, my limits on my policy, but it wasn't that much. I have a $1 million excess policy. So I have a $1 million policy if anything happens where I get sued, or there's an accident, or somebody falls on my property, I've got a $1 million exemption, because the insurance company's gonna take the risk. I pay $171 a year. I hate insurance. This I don't mind paying. $171 a year for $1 million of coverage, it's a no-brainer. It's really easy. Call your agents, they'll be happy to sell you this policy. Okay, now, I've got some time left to talk about long-term care planning. How many of you want to go to a nursing home? Those of you in the front, nobody raised their hands, okay? How many of you want to be poor? Nobody. How many of you want to be poor the day you go to a nursing home? Everybody, yeah, exactly, okay? You want your cake and eat it too. Not gonna happen, okay? It will not happen. Because Medicaid only pays for you in a nursing home if you are poor. Poor means if you are single, you can have $2,000. And you can have a small life insurance policy and a burial account, and you can prepay your funeral, peanuts, okay, in the big picture. Everything else has to go. You gotta withdraw your money from your IRA, cash in your life insurance maybe, sell the house. It all has to go, unless you've done some planning ahead of time. If you're married, you get to keep a house, one house, as your principal residence, and the spouse at home gets to keep $148,620 this year. That changes every year also. So that's not a whole lot of money. But here's how this works. The government doesn't want to pay for your long-term care. Okay? They want you to be poor. They want you to spend your money down to $2,000 before they're going to pay for your care. Well, I mean, I know what the nursing homes in town cost because I just was at one the other day. It's $15,000 a month. It doesn't take long to spend a lot of money. Okay, 1 year is going to be $180,000 plus all your other expenses that you have to pay for. So your money that you worked really hard for, you were making $15,000 a year, and now you're paying $15,000 a month for long-term care. So So you are somewhat penalized for saving money. I don't make the rules, I'm just a messenger. Okay, don't shoot the messenger. So, you know what the rules are if you're married or single, right? 2,000 or basically about 150,000 plus a house. So what do you do? Well, you have pretty much 4 options. I want somebody to jump up and down when you hear one of my options that's available to you that you're really excited about, okay? Because you're not going to like anything I have to say. Okay, so the first option is you can give all your money away. Give it away now, you got a 5-year waiting period. The money has to be out of your name for 5 years before Medicaid will pay for your care. So if you give $17,000 to each of your kids, that's subject to the 5-year penalty. Doesn't matter. And if you get a caseworker who's really petty, and you gave your child $500 at Christmas, and then you went to the nursing home the next year, they're going to say, that's subject to the penalty too. Somehow $25 and $50 seems under the radar, but $500, they might count it. They might not. It depends on the mood they're in that day when they're processing your application. But they have a right to say, that's subject to the 5-year look back. So you can give all your money away and get poor. One of the things I like to do, however, is the deed with the life estate. Because you give the house away, did you really give it away? You still have a right to live in it. You still have the obligation to pay the water, the sewer, the taxes, the insurance. You still have that obligation. So you still have the house. Do you have to change the keys? No. Okay, you go to bed, it's the same house that you had yesterday. Except that now you got the clock ticking on the 5 years. Because at the end of 5 years, you have a big party and celebrate, invite me to it, that you beat the system on the house. Giving away the house is easier because you still have use of it. You still kind of live there and own it. Give away money, you don't have that anymore. Okay? So you gotta think about what you're doing. If you're giving away the house, that's great, but if you've got hundreds of thousands of dollars in the bank, then you haven't protected that money. So maybe you need to do something else. So when you give away money, it's not yours anymore. Is there a gift tax to pay if you give away a few $100,000? You have to pay a gift tax if you give a few $100,000 in the house to your kids? No, why not? Because you didn't hit $12 million. And what's the gift tax level in Massachusetts? We don't have one. So isn't that easy? It's easy for me to give away your money, okay? Just make sure you're giving it to the right people, because once you give it, you got the 4 Ds. If a child dies, gets disabled, gets divorced, or has a lot of debts, that money that you put in their name is now their money. And if they get sued or get divorced, that money is part of their name because you didn't keep any strings on it. Okay, you gave it away. It's not yours anymore. They might put you behind the 8 ball, right? If you give it away, you can't get your money back because now it's somebody else's money. I don't know what the answer is, but that's the first option. Nobody's jumping up yet, okay? So let's say you want to give some money away, you want to put the house in the kids' names, but you don't really want to give it to them now. So now you put it in an irrevocable trust. The irrevocable trust is truly irrevocable, irreversible. You put money in there, it's not coming back to you, okay? You cannot get it back. The only thing you can get out of an irrevocable trust for Medicaid purposes is the income. And your house produces no income unless it's a 2-family house, in which case you could get the income from that. But if you put stocks and bonds in there, you get the dividends, you get the interest, you can never get the principal back. It's gone. And you still have to wait 5 years. You gotta stay healthy for 5 years to make this work. My bad joke is, you have to stay healthy for 5 years. You don't have to stay alive for 5 years. Oh, that's one of my better jokes. You didn't like that one, huh? My wife doesn't like that one either. Okay, so that's option 2. Now, I call this, and I have my own theory about what I call things, but I like to remember them, so I call it an intentionally defective. Defective means, for tax purposes, the income is still yours. So the trust won't have to file a separate tax return. And it's an income-only trust. So the initials are IDIOT. Idiot, okay? Intentionally defective income-only trust. Okay, that's what I call it. It's an irrevocable trust. You can only have the income from. You gotta wait 5 years. After 5 years, whatever's in that trust is then protected. But you can't get it back. But you can put language in the trust that when you pass away, the money will go to your kids, or skip the kids and go to the grandkids, or leave it to charity. It's another form of a trust, but it's an irrevocable trust. You can put your life insurance in there. You can put anything in there you want. I have a guy who has 17 cars. He's put 15 of them in that trust. Because if he went to the nursing home, they would make him sell all his cars. So now the cars are in the trust. If he wants to sell a car, his trustee can sell the car or buy a new car, but he can't make that transaction. His friendly trustee has to be doing it. His friendly trustee is his daughter, who kind of just does what he tells her to do. But if she doesn't want to, she doesn't have to. So you run that risk. Okay? That was option 2. Option 3 is not going to be for some of you. It's called long-term care insurance. Okay? You can buy insurance. It covers the risk if you go to a nursing home. Some of you are too old to get it. Some of you don't want to spend the money to get it. It's going to be expensive. Once you hit 60, the rates go up really fast. And sir, you're walking with that walker, that's an automatic decline. You can't get insurance if you have anything that you're using to walk with. Okay, automatically. Doesn't matter how competent you are or how healthy you think you are. Okay, if you have that walker, you're declined. It's that easy. So some of you can't get it, some of you won't want to get it because it's going to be too expensive. Because when you get to your 70s, it could cost anywhere from $7,000 to $10,000 a year to buy these policies. They're expensive. But look what it's paying for. It's paying for you to have home care or nursing home care at $10,000 to $15,000 a month. That's a big insurance risk that the company is taking. Because they say that 1 out of every 4 people 65 or older is going to spend some time in a long-term care facility or need home care. Well, there's 4 of you and me. It's not me, so it's got to be one of the 4 of you. Okay? She says it's not her, so it's one of the 3 of you. She says no. She says no. Bye-bye. Okay. That was option 3. A little subset of that is there's a newer product out that you can buy. Long-term care insurance only covers you if you end up in a nursing home. If you never end up in a nursing home and you don't need home care, all the premiums you paid for all those years is gone. Just like if you're paying for your car insurance, your homeowner's insurance, you never make a claim. The difference is this costs a lot of money. And you're betting against yourself because you're hoping you never use it. That's what you do when you buy life insurance too, right? So there's a new policy, I call it a hybrid policy. It's a life insurance policy. Let's say you buy a $200,000 hybrid life insurance policy. So you're paying the premium on it. You can pay premiums every month, or you can pay a one-time premium and just be done with it. And if you need long-term care, you can access the death benefit while you're alive as an accelerated benefit during lifetime that will give you up to $200,000 to pay for your care. That's a pretty good deal, because if you buy life insurance and you never use the home care part of it, then you got the life insurance that your kids will get. If you need it during lifetime, it gives me or your other lawyers an opportunity to do some planning. So the day you get sick and you go to the nursing home and we go on claim to start using that $200,000, now I've got some time where I can start giving some money away so that at the end of 5 years, you're now impoverished and now you qualify for Medicaid. So it's a great thing. I've got some clients who don't want to buy it. Their kids have bought the policy on the parents. The kids are buying the insurance on their parents so that they're ensuring that if the parents go to the nursing home, they won't lose all their inheritance. And if the parents never go to a nursing home and the parents die, the kids get the money back through the death benefit of the life insurance policy. Now, if you buy these policies, maybe you have to be, and your kids are paying for it, and you go to your kids' houses, maybe you have to be careful what you're eating for dinner there, okay? But it's not a bad option. If you can't afford it, you can tell your kids about it, and maybe they want to help pay the premiums to insure the risk. It's just an option, okay? Just like my client last year who called me and said, listen, my parents will not do their estate plan. They just don't want to pay for it, they don't want to do it. So for Christmas, they bought a gift certificate from our office to get the estate planning done. January 1st or January 2nd, they called the office and made an appointment, got the plan done, didn't cost them anything, the kids paid for it. And the parents really didn't do much about giving away any money for long-term care planning. And they didn't have a taxable situation, but they got their wills, their health proxy, their power of attorney, and their homestead. They got those documents done, which they didn't have. And the kids are happy, the parents are happy, I'm happy. It was a good day, okay? So, let's go back a second to review. Can I keep going even though it's after 7 o'clock?
Yes, you can keep going.
All right. If anybody has to leave, that's okay, but you'll miss the best. The best jokes, that is. And the best props. I have more. Okay, so, number one option, give money away, outright. Option two, irrevocable trust, the idiot trust. Irrevocable trust, income only. Option three, long-term care insurance or life insurance. No one's too excited yet, are you? Guess what option 4 is? If you don't like options 1 through 3, this is option 4. And you're pretty good at this one. Do nothing. Take your chances and see what happens. And if something happens, we'll get into high gear and see what we can do. There's always...
Excuse me, I'm going to the bank to do one.
Option 4 is do nothing. But there's still things you can do, okay? Because if you get sick, we can still give money away, but we still have a 5-year waiting period. So if you have enough money to carry you for 5 years, great. If not, then maybe you just have to spend all your money. So in some cases, we decide what we want to do, talk to the clients, they make a decision, and the best way to make the decision is to work backwards by what you don't like the most. So if you don't like, and you're not going to get insurance, scratch it off. Now we have 3 options. Next option, you don't want to do a trust. Scratch it. So now it's do nothing or give money to the kids. You don't have to do it all. You don't have to give them all the money. Maybe you just give the house and you keep the cash. So the cash is at risk, but the house is protected. The house could be your single largest asset. And that's easy to give away with the life estate. Okay, not a big deal. So now, option 4 still has some subsections. And here's some things that you can do. Don't try this alone, okay? If you're married, this works. If you're single, it does not work, okay? It's not a good option if you're single. So those of you who are single, maybe you want to get together with some other people who are single and talk about that, okay? So, remember I said earlier, if you have more than the $148,000 plus the $2,000 for the spouse in the nursing home, you got to spend all that money down to get to that level if you're married. Okay? So here's how Mass Health looks at this. If you're married, they look at all your assets. And it doesn't matter if you have an IRA or she has an IRA or all the money's in her name and you go to the nursing home. Her money counts towards you because you're married, and that's a marital asset which is counted to be joint in their minds. It all counts if you're married. Okay? Doesn't matter who owns it. You can have the kids' names on it. It's still presumed to be yours because it's still your social security number and it's your name first on the account, so it's still your money because your kids didn't contribute to that account. I'd like to have $1 for every time the kids say, but I put money in that account. No, they didn't. They never put money in the parents' accounts. My kids have never put $1 in my bank account, okay? I only put money in their accounts, in their kids' accounts. It's a one-way street, just how the Mass Pike runs. It's one way to Boston. It's the same thing. So, Your assets are construed to be joint, but listen to this, your income is not joint. So if you go to the nursing home, your income goes to the nursing home. Her income she gets to keep. So if you're getting Social Security and a pension, it's goodbye money, it's going to the nursing home. Now there are ways we can get to keep some of that money if your income is very low and you don't have much in assets. There's things that we can do. But let's say that your income is pretty good and your assets are pretty good also, like, a few $100,000, which isn't really a whole lot of money, but it's enough to disqualify you for Medicaid. So what would we do? Well, her income is exempt, but we got $300,000 of excess assets. Let's say the level is $150,000 and you've got $300,000. So $150,000 has to be spent, $150,000 she gets to keep. Do we all understand that? You all with me on that, or did I go too fast? You got it? Okay. So she gets to keep $150,000, but I got $150,000 of excess assets. In 10 months, at $15,000 a month, that money's going to be gone. We're smarter than that, right? So what I would do is, I would take the extra $150,000 and go to our local financial advisor, and I would buy an immediate annuity. Some of you might have annuities where you put the money in and it accumulates for years and years and you don't take it out yet. This is the opposite. This is you put the money in and you take it right away. Okay? So once again, she has $150,000. We have an annuity for her of $150,000. She's getting the income from that annuity. Whoa. God, that was like David Copperfield. Okay? That was magic. I made that $150,000 go away, and now it's income. You get the income. Does that income have to go to the nursing home? No. So now you have a house, you have $150,000 in bank accounts, you got this annuity that was converted, so it's only income that you're getting, but you're getting the income on $150,000 and part of the principal too, and he's getting his Social Security, which is going to the nursing home. Does Medicaid cover him? They do. What about the 5-year look back? We gave her $150,000. You're a marital unit. There's no penalty between spouses. 5 years does not apply between spouses. So he's now at the nursing home, he's eating his green Jell-O, having his bingo game every day, and you're sitting home counting your money as you get it every month from the annuity and the $150,000, and you got the house. Not a bad deal, but you got to do it exactly right, because if you buy it on the wrong day, it's wrong. So why don't we buy an annuity for you now? Why don't we buy her the annuity now? Because what happens if we buy the annuity now, and she's the first to get sick, and she goes to the nursing home? Now that income is following her to the nursing home. So do you want to know who's going to the nursing home first? For an additional fee, I'll look at my crystal ball for you, okay? And I'll tell you. But that's why you don't buy this annuity now. You only buy it when someone's on their way to the nursing home. That's an option. And then sometimes we don't buy the annuity because the spouse who's in the nursing home has somewhat limited life expectancy. And if I think you're not going to live for maybe a month, I'll say, let's suck it up, pay for the month, call it a day, don't go through this process. But then, that's a roll of the dice, okay? Because if he lives a couple months, we bet wrong. We should have bought the annuity. So, we have to look at all the situation. Nobody is the same. We have to take a look at everyone's situation at that time. So if you're married, this works. If you're single, the annuity doesn't work, because if you buy the annuity, the income follows you to the nursing home. So that doesn't help. And then when you die, if Mass Health did start paying for you because you didn't have the assets, because you converted it to an annuity, bless you, Mass Health can claim against the annuity balance when you die up to the amount that they paid. So it's not a good option if you're single. The best option if you're single is give it away, do the trust, or take your chances and stay healthy. Okay. Another option if you're married. I don't like to even talk about this. But because all your assets are construed to be marital assets, remember, because he's going to the nursing home, okay? If you want to keep some of those assets, I always hate to say this, you can terminate the marriage, become single, and now you have the assets and he's in the nursing home. You can visit him every day, but you're leaving him limited assets and you have all the assets and you didn't have to buy the annuity. It's not a pretty picture, but it's something that we've done in the past. It's a last resort, but it's available. Not a pleasant thing. I've got some people who've gotten divorced and their kids don't know they're divorced.
They don't look to make sure you've been divorced for 5 years?
No, because when you get divorced, it's a judgment from the court of how much money each person gets, and that's a court order, so it's not subject to the 5-year rule, it's an exception. But we also have to convince the judge that it's the right thing to do. So that's, it's a tough thing, because you might be losing some benefits because now you're not married. So if there was insurance that your spouse was getting, maybe you don't get it, and if there's a death benefit, if you were married, you got it, but if you're not, you don't get it. So there's the cost of insurance. There's lots of issues we have to look at before you consider that. Okay, so we've talked about wills, trusts, health proxies, powers of attorney, homestead, gifts, long-term care. Did I miss anything that you came here to hear about that I didn't talk about? Yes, ma'am.
Is there such thing as a backdoor to an irrevocable trust?
Okay, wait a minute, I'm gonna have her repeat the question.
The question was, is there a backdoor to the irrevocable trust? No. The answer is no. It's irrevocable. Some people will put clauses in there that say that the kids can get money during their lifetime. I won't do that because Mass Health changes the rules all the time and I don't want this to fail. If I'm doing this, I want it to work. If it doesn't work, you're not going to be happy because now you have a false sense of security that you thought that this was going to work and it didn't. So, it's got to work. I won't take any chances. It's like, I say it's black and white. It's like either you're pregnant or you're not. Okay, there's no in between on that, as far as I know. Okay? All right.
How much does it cost? Estimated to make a will.
I can't believe that someone waited so long to ask that question. The question is, what does it cost? It all depends on what you need. Okay? If you're just doing the will, the health proxy, and the power of attorney, there's a range. And it can be anywhere from $500 to $750. If you tell me that you're making 25 requests and you make 10 different changes to the document and you want to have all these meetings and you're saying you just want to do these documents, but when you sit down, you're taking all this time to talk about long-term care planning and tax planning, it adds to it. So most lawyers will charge by the hour. I like to give you a flat fee, but if I give you the flat fee, that means everything else you're on the clock for. So I kind of want to know what you want before I start the process so I can give you a realistic estimate of what the cost is. If you're going with the irrevocable trust, you're talking a few $1,000s. Okay? So the range, 500 to a couple thousand, that's my best guesstimate for you. But if you have a lot of money and you're doing the tax planning, you could be talking several thousands of dollars. But if we do that, we're saving probably hundreds of thousands. So you have to, look at the pros and cons.
Is there an advantage to working with a lawyer who's in a big practice like yourself versus a lawyer who is the only lawyer in the practice?
So that question,
Can you repeat the question?
the question is there a benefit to working with a lawyer in a larger firm or maybe a sole practitioner or a smaller firm? So that question, I couldn't have planted any better. That's like taking the rabbit out of the hat, okay? That was a magical question for me. The answer is no. I mean, we have a big firm. We have more people doing what I do. But there are some very good sole practitioners who can do this planning. I think if you wanted to get somebody, you should make sure they're a member of the National Academy of Elder Law Attorneys. That's NAELA, N-A-E-L-A, which is an organization that, you know, I couldn't do what I do if I didn't belong to it, because I learned so much from those people who taught me everything over the years. And we have a Mass chapter. Massachusetts is the largest chapter in the whole country of NAELA lawyers, so there's lots of us out there. About 6 years ago, I was actually the national president of NAELA. Hard to believe that just me in Springfield, Massachusetts became the national president, but it was pretty cool. But no, I mean, yes, we can probably do more than a sole practitioner, but there are some very good sole practitioners out there. But you wouldn't want to pick somebody who does a bankruptcy in the morning and a closing in the afternoon and a divorce and then does elder law. You just can't do it all that way. I used to think I could do it all. Not anymore. I've given up real estate. I've given up most everything. I just do estate planning and elder law. There was another, yes sir. My rich client.
Revocable trust
Revocable trust.
versus irrevocable.
Good question.
What's the benefit?
Revocable versus irrevocable. Remember I was talking about putting assets in a trust to avoid probate? That's a revocable trust.
Right.
You can do the same thing with an irrevocable trust and avoid probate and get the benefit of getting the 5-year clock ticking for Medicaid purposes. So you can have one versus the other. The difference is, one you still control and it's still yours. The other one, you haven't preserved any assets from long-term care planning and it's all still your money. So you've got to weigh that. You could have two, you could have one of each if you wanted. That's up to you.
If you have a trust, do you have to redeed the house?
If you have a trust, you have to redeed the deed.
How about your bank account?
If you have a trust, you should use the trust. If you have a trust, put the assets in the trust so it avoids probate. If you have assets in your name alone, and you have a trust that's not funded, when you die, we have to probate your estate to get those assets into the trust. Put them in now, that's why you did the trust. Yes, transfer the deed, transfer the bank accounts, transfer the stocks. You cannot transfer the IRA. If you transfer the IRA to the trust, that's considered a withdrawal, then all that money is income taxable. Don't do that.
You talked about giving money to children or grandchildren. As far as giving a grandchild money for college, does the money have to go to the college?
Okay, the question is, I'm probably going to come back with another question to you. If you want to give money away, you want to give money to your grandchildren for college.
Right.
You can either put the money in their names with their parent as a custodian. You can put the money in a 529 plan, which is what I prefer, or you can pay directly to the college. You can't give the child the money, or the grandchild the money and say, use this for college. You have to pay the college directly. You don't get a charitable deduction, but it's okay because you're giving them the money.
Okay, well that was my question. She's in college.
She's in college, you should be paying the college directly. The room, the board, the books, the new computer, you can do that now, okay? With the money that you can pay directly, okay? But you shouldn't give that grandchild the money. You should buy the computer, you should pay for the college, write the checks yourself, or put it on your Visa card. Don't give the grandchild the money.
Okay.
You want to comment on companies like LegalZone?
Do I have a comment on LegalZone? Do you really want to hear my comment? What's the old saying? He who has himself for a client has a fool for a client, or a lawyer, or something like that. I mean, you get what you pay for. My biggest fee I've ever charged was a client who wrote his own will. He wasn't my client. He wrote his own will, and it was contested after he died. It was in litigation for 2.5 years. I made my largest fee on that. So yes, I like LegalZoom. But, you know, they say it's tailored to you because you do it online and you call somebody and they walk you through it. They don't know what questions to ask you. And they miss things. Like if you have a child who's got a problem, you need a trust. Or if you have a disabled child or grandchild, they shouldn't be getting the money outright because they're going to lose their benefits. They don't know. They still call people in Massachusetts executors on their forms. The last I saw. The last time I saw it, they called it the state of Massachusetts, not the Commonwealth of Massachusetts. It's just not It's not up to my standards. You can probably do it. It might work. If it doesn't work, I can't defend it because I didn't write it. I can do my best, but I didn't ask any questions about what the document was going to include or not include. So I see these documents all the time. Most of the time, they need to have the document revised. But it might get you started on the process for cheap money. But don't try it at home.
I mean, we have time for one more question, and this gentleman has been, he has his hand.
Who said he was a gentleman? Emily.
My wife.
She's right.
On the homestead, if you take out the Homestead Act, can you then put on your kids' names in the house?
Okay. So the question is, if you have a house and you deed it to the kids with a life estate, you still
No,
you give it away,
you take out the Homestead Act first.
and then you
Then later on, can you put your kids' names on the house?
yes, you can put your kids' names on the house. Did you keep your name on there also? Did you reserve the right to live in the house, or did you just give the house to the kids?
I
Good.
haven't done either one yet.
Okay. If you give the house away directly to the kids and you don't have any more rights, your homestead's gone. You only get the homestead if you own the house and you live in it. Okay? And it's your principal residence. Once you take your name off the deed, it's no longer yours. If the kids don't live in your house with you, they don't get homestead on your house.
But they get the other aspect though.
Well, they'll get the benefit of after 5 years protecting the house from Medicaid.
All right.
Is that clear?
Yep.
Okay.
Say yes.
All right. All right. Well, I just want to thank you very much for letting me be here. It's always a pleasure to see you. It's been a long time, so thank you. You've been a great audience. Thank you so much.
Thank you, Attorney Darling. And thank you for being here and being part of the Mass Education Law Project. I always let my seniors know that, when we do something in the evening, I try to get people home before it gets dark. We're lucky, yesterday was the longest day of the year, so it's still light, so hopefully everybody will get home before it gets dark. On the table in the lobby on the way out, we have some of these books. These are called the 2023 Elder Law Education Guide. This is the 14th edition. It's published by Mass Bar Association. I don't have enough for everyone in the room, but so please, one per family if you're here with parents, kids, or whatever, until we run out. I put the ones that we got for 2023, and I also put some from last year, and it's a great guide. We keep 3 of them here at the Senior Center, and they stay, they have a little tag on it saying, this is the property of the Senior Center. So if you don't get one, feel free to come. We keep them in the Fireside Lounge. You're welcome to look at it. And if there are some pages of this, if you don't get one and there's some pages that you would like photocopied, just so happens that my greeter, Sandra Fisher, is right over there. Stand up, Sandra, so they know who you are. So Sandra works the front greeter's desk. So if you look through this and you say, oh, I'm particularly interested in these 6 pages, take them over to the greeter's desk and Sandra will make a copy of it for you when you come in, okay? So, but otherwise you're free to take these. They're out of the basket until they're gone. Attorney Darling, thank you so much. You always wonder, like, he's an attorney, so he brought this big, briefcase, and I thought he had all of these really important papers, but he just had really all these props. He's like a magician. So let's give him another round of applause. Thanks, folks.